To the Virginia Transit Association's Procurement Webinar. I'm Lisa Guthrie, the Executive Director of the Virginia Transit Association and the moderator for today. Our technical expert is Jamie Crawford, our VTA Program Coordinator. I'd like to take a moment to thank those of you who pre-submitted questions for today's webinar. We are recording it for those who are not able to participate, and we will make the webinar available on our website along with the slides for on-demand viewing. And even though many of you have submitted questions ahead of time, some other questions may occur to you throughout today's webinar. So if you have additional questions, we ask that you are able to type them in, and we will take them up at the end of today's webinar. So this is how you do that. Look for the webinar panel on your screen and simply type your question into the question box. And they will be answered at the end of the webinar, but you can submit your question at any time and we'll hold on to them until the end. And remember that the audience is muted, so we'll be unable to hear you during the webinar. We have two very important presentations today providing you with a great deal of information about procurement. First of all, we will have Tony Tarone and some of his staff. Tony is with the Region 3 of FTA, and he'll be answering pre-submitted questions about procurement from the federal level. Then we'll have Jamie Motley, the Director of Financial Planning and Budget for the Department of Rail and Public Transportation here in Virginia, and he will discuss procurement from a state level. And with that, it is our great pleasure that we welcome our first presentation from FTA, Tony Tarone, Director of the Office of Program Management and Oversight. Tony?
Thanks, Lisa. Good afternoon, everyone. As Lisa said, my name is Tony Tarone. I'm the Director of the Office of Program Management and Oversight here in FTA Region 3. Joining me today for this presentation will be Jay Fox, our Regional Counsel, Anthony Romero, our Procurement Specialist, and we have two of the three Program Managers for Virginia, Karen Rocher and Ann Delecki. I also want to note that if you ever have procurement questions moving forward, you can contact your program manager, either Karen, Ann, or Ron, and then we'll get back to you through them. So we're very happy to be participating in this VTA-sponsored procurement webinar. I have to admit, when Lisa approached us about conducting a webinar, I was a tad bit apprehensive. Reason being that procurement is a huge topic, and I didn't know if an hour would really be able to address all of the issues associated with procurement and actually do it justice. But we put our heads together and we came up with an approach where we thought a Q&A, pre-submitted questions and answers might be the way to go. So Lisa was kind enough to survey the Virginia grantees and come back to us with a number of questions that you submitted, and I think our presentation today by Jay and Anthony will address the questions that you have provided us. Procurement is, like I said, a huge topic. It's also one of the, it's actually the area in our triennial reviews that ends up having the most findings each year. For example, last year in fiscal year 14, we conducted 19 triennial reviews in our region, and there were 116 findings. 31% of those, or 36 of them, were in the procurement area. And they basically focused, for the most part, around FTA clauses, the cost-price analysis, and the independent cost estimate. So those were the top areas within the procurement where we had the most findings. So hopefully we'll take care of some of those questions today that deal with those issues. But I also want to let you know before we get started that there is an abundance of training out there on procurement. We're just going to kind of skim the surface here today. But I just wanted to let you know that in addition to our triennial review workshops, which we conduct annually, in fact, the last 2 years we've had 2 workshops each year, one in Richmond, Virginia, and we hope to continue that process moving forward. But at our TR workshops, we spend about 2 hours, I guess, on this topic. So for those of you who are getting a TR this year, you were there and you know that. Next year, like I said, I hope we'll be in Richmond again for a workshop. Of course, we give priority to those grantees who are receiving a triennial review in the upcoming fiscal year, but I would also encourage other grantees to possibly attend the workshop, especially if you have new staff on board. They're a good learning tool as well. In addition to our TR workshops, NTI offers a number of procurement training courses. I had Karen check the website yesterday, and by the way, that website's www.ntionline.com. That's one word, ntionline.com. And Karen came back with 5 procurement-related training courses. There are a number of them in this area. Actually, in Pennsylvania, we've got 3 of them in the spring, and 1 in March in State College, and 2 in April, 1 in Philly, 1 in Pittsburgh. But that's only up to that date. I'm sure as the year goes on, NTI will post more and more procurement classes. And finally, just our website is a good reference tool for any procurement questions you might have. 4220, our third-party contracting guidelines are there on our website. We also have a best practices section. Now that section is being updated constantly, but it's got a lot of good information on there as well. And finally, just our staff. I mean, we have a procurement specialist here in our region. Our program managers have a lot of procurement experience, and our deputy regional administrator, Reggie Lovelace, actually has an extensive background in procurement. So lots of tools out there available for you if you have procurement questions. So they're available, we're available, and we're here to answer your questions. So Karen's telling me to hurry up, and I'm going to turn it over to Jay so that we can start the presentation.
Good afternoon, everyone. In responding to the questions, I erred on the side of being a little bit basic, and then maybe we can answer some more detailed questions if we have time, or certainly submit them to us after the webinar. And the reason we're going to stick to some of the basics is because we've seen in some of the issues that have, a couple significant issues that have occurred over the last couple of years, a misunderstanding of some basic principles. So let's start with one of the questions which inquired about cooperative purchases and piggybacking, and looking essentially at the use of existing contract rights, joint procurements, and schedules. So the first, we've moved to the first slide. The first principle, and highlighted there in red, is piggybacking. So first, you need to know that it's a pet peeve of mine that I do not like that term, because it's really the rest of the part that's most important. It's an assignment of an existing contract right. I find that piggybacking is often confused with joint procurements and cooperative purchases. This is, if you are piggybacking off of somebody, essentially what is happening is you're being assigned a contractual right from another party, obviously usually a grantee. We can go to the next slide. So the first thing you should know is that piggybacking is generally disfavored. Why is that? It's because the recipients are expected to limit their procurements to the amount of property services required to meet their reasonably expected needs. And this was the subject of the 3 procurements that received a lot of attention from the FTA a couple years ago, one in Akron Metro, out in California, Santran, and in Florida, Orlando, Lynx. Each having their own flavor, but certainly the one in Akron revolved around piggybacking, and not only that, but it was not an actual assignment of existing contract right. And we'll talk about that a little bit more in a moment. But the bottom line is grantees are expected to adequately foresee their procurement needs and procure accordingly. So if you are going to take advantage of an existing contract right, that is piggyback off of someone, there are a few things that are required. First, you have to ensure that the terms and conditions of the contract comply with federal requirements. That's one of the things that we've seen as a problem in the past. Grantees assume that another grantee has done their due diligence, has done their homework, and only to find out that there are significant problems with the contract, or in the case of Akron, problems that could have resulted in a disallowance. Not only that, but oftentimes the existing contract right exercised is an option, and if so, the option has to be evaluated before awarding the underlying contract. So if it's not, it's essentially a sole source procurement because all that's being done after the fact, at the time of the option actually being exercised. The same for negotiated option prices. They have to be reasonably determined from the terms of the contract. Again, otherwise it's a sole source. All I can say to just wrap up piggybacking, essentially, again, my preferred term, assignment of existing contract right. If you're going down that path and you have any concerns, feel free to check in with the regional office. In fact, that very fact led to us discovering the problem out in Akron because we had a Region 3 grantee who did that, and I think who was very glad that he did do that before signing on to that contract. We go to the next slide. So next is a joint procurement, and as we'll see in a moment, this is the preferred vehicle. 2 or more grantees use a single solicitation to enter into a single contract for specified deliverables. Let's go into the details of that. Next slide. So unlike assignment of contract rights, these are generally encouraged. Why? Because, one, they're more efficient administratively, and 2, they're more efficient in terms of pricing. The small grantee that can only afford to buy 2 or 3 buses certainly benefits from throwing in a joint procurement with either a number of small grantees or larger grantees. Again, one grantee may take the lead, but just like assignment of rights, all grantees must ensure that the terms and conditions of the contract comply with federal requirements. So, it's the onus is on you that if you're, leaving the procurement requirements to another or to a lead grantee, that you are not just simply stepping away from the process, that you're making sure that it's being done properly. Contracts, a nice thing about the joint procurements, they can be expressed as a total minimum or a total maximum, but there still must be a reasonable expectation in terms of the amount of service, the amount of goods at the time the contract is awarded. So we don't want to see contracts that have almost deliberate excess that ultimately permit assignment, which would be permitting what's known as piggybacking. This is the issue we ran into in Orlando with Lynx, where there were over 1,000 buses identified in joint procurement, so much so that as some of the grantees could not come in for the buses that they had signed on for, the manufacturer began to search around for those who wanted to be assigned either the rights in the base contract or in the options. And that becomes a problem. And in fact, in that case, it almost felt as if the manufacturer had essentially set up a dealership at Lynx because of the number of vehicles involved. So, and that was really the major problem was the fact that so many of those stated buses to be procured ended up being unfulfilled because of one grantee or another not being able to do so. So let's go to the next slide, which is schedules. So this was a big issue last year. We'll talk a little bit about the Minnesota schedule, or really, buying cooperative or buying consortium. So schedule is a negotiated arrangement with several vendors providing an option for acquisition at established prices. And we may hear from DRPT about this in a little bit, but Virginia has a state schedule, which when I see grants come through from Virginia grantees, I often see that they're purchasing off the Virginia schedule, and that's no different than many other states. For some specifics here, if we go to the next slide, use of state schedules. So buying cooperatives should be, when you see cooperative or consortium, you should be concerned. Purchases are often disallowed for lack of state participations, absence of finite quantity, lack of competition, and you can all put that in the bucket of not complying with federal requirements. Recently, actually in Virginia, we had a request from a grantee wanting to know whether they could purchase off of the Virginia Association of State, College, and University Purchasing Professionals. Again, we had a lot of concerns about that. This is not an entity that's doing federal procurements, and certainly not federal transit procurements, and we highly recommended against using that to fulfill a contract with federal funds. Even when you're using a state schedule, you should make sure that either the state is procuring with all federal clauses, or when you're submitting your purchase offer, a purchase order, that's submitted with what the standard federal clauses would be if you were doing your own procurement. Out-of-state schedules became a hot issue because a number of grantees were purchasing off of a Minnesota state schedules, which were all under a buying cooperative, as people kind of paid a membership to buy in, and then they could purchase off the Minnesota schedule. The FTA stated definitively that grantees located outside of a state are not permitted to purchase from that state schedule. And that doesn't include joint procurements or piggybacking, assignment of rights when permitted, and with state transportation entities. So when we're not purchasing off a state schedule, we're actually going in as a joint procurement with New Jersey Transit or Maryland Transit. That's fine. It's the schedules that we're most concerned about. The restriction has its roots in the Common Grant Rule, which gives deference to a state when procuring property and services, and therefore grantees need to look to their own state when they're using scheduled purchases. Just one last thing on this, there has been an issue that's being addressed by the Office of Chief Counsel, which is where a state doesn't have a schedule, and they can actually go in on another state schedule and make it their own, and in that case, you would be able to buy off of the outside state schedule because, as an example, if State X says we're going to be using statewide schedule, then essentially that's your schedule. I don't think we have that issue in Region 3. That was in another region, but if that ever came up, actually, if that situation came up, I would say check in with us first just so we can make sure that everything is cool. So going to the next slide is just kind of the summary, and sort of follows this logical frame here, which is the piggybacking, joint procurements, use of schedules. They're all sources. And if you're using a source, it means that you, under our master agreement, under all the requirements that you are certifying to and assuring every year, have to be met, and your failure to ensure the compliance risks both disallowances and litigation. I will say that we have plenty of findings each year in our triennials. They don't necessarily lead to disallowances, but we have seen significant problems in the past where that's happened. And one comes to mind, a serious departure from competition requirements on a bus purchase that resulted in both a disallowance and litigation between the grantee and the bus manufacturer, who wanted to fulfill the contract that had been agreed to. So that's that. We'll handle questions at the end. Let me go through Buy America. It's our next series of slides. So Buy America Basics. This is your basic standard here. No funds obligated unless all iron, steel, and manufactured products are produced in the United States. I'll handle iron and steel real quick. We're talking about structural iron and steel. So that rivet you're fine with, but anything structural, has to meet Buy America. Let's talk about the more important one that you're going to deal with on a regular, I shouldn't say more important, but the one you're going to deal with on a more regular basis, which is manufactured product. We're just going to follow this 1, 2, 3 because this progression is important. The manufacturing processes for the product have to take place in the United States. All of the components of the product must be of U.S. origin. But most importantly, a component is considered of U.S. origin if it's manufactured here, regardless of the origin of its subcomponents. And that's oftentimes our first question when we have a Buy America inquiry, which is, are we dealing with a subcomponent? Because that oftentimes will end the question right there. Just keep in mind, for those of you who are building facilities, that components in a facility oftentimes are systems. So heating, HVAC, that would be a system. So that's your end product. So all those components of that end product, of that heating system, have to be U.S. origin, and then the subcomponents at that point, as long as the components were manufactured here, would be fine, no matter where they were sourced from. That's one to check in with us all the time on, because you don't want to be in a situation where you violated Buy America, particularly in a facility where you may end up being in a real problem where you have a fixture and it can't be removed, and there's some big issues. So any question on Buy America, please come right to the regional office. We'll resolve this as quickly as we can. Buy America, a couple other principles for Buy America, because we get this all the time. FDA Buy America is what applies to FDA projects. FDA Buy America requirements are different than Buy American Act. There are a number of treaties that apply under the Buy American Act, which are not recognized by FDA for their Buy America requirements. And this is something we often get all the time, which is a citation from the contractor to a particular treaty permitting the purchase of a particular component or end product that does not apply for FDA Buy America. Again, once again, a reason to come to us. Same thing for FHWA. Their Buy America requirements are different, and we have some grantees that there are some bus purchase programs through FHWA. There was a recent memo between FTA and FHWA that if that's happening and it's for transit purposes, that they really should be purchased under FTA Buy America's requirements. So, the next one I really want to talk to you very briefly. Again, this is for those who are building facilities or in some way utilizing a larger utility contracts. Just keep in mind that utility contracts are subject to Buy America. The Booth letter that came in, and that's Jeff Booth, who chairs the New Starts Working Group. He asked a number of questions when this issue came up, whether the FDA can apply Buy America to utility contracts, and two, whether the application was a change in policy and therefore required notice and comment. If we can go to the next slide, FDA determined that Buy America rules apply to the entire project and therefore apply to utility contracts, and that was not a change in policy. It had always been, and therefore the applicable provisions for Buy America need to be part of the entire project and on all contracts and agreements. There has been some change in those, not change, but interpretations there, and there is some room and some exceptions. What I would say is, rather than going into them, because that's a whole other topic, if you have any questions about utility agreements, please let me know. Realize, though, that it's probably one of the only areas where there's actually segmentation allowed, and a decision regarding Southern California Edison. The small purchase agreement exemption applies to utility agreements separate and apart from the project. So that's, you got about $100,000 of utility services before one would look at it from a perspective of complying with Buy America. Next slide, which is evolution of FDA circular. We had a question about this, asking about how the circular has changed. This is the circular is a guidance document that summarizes the federal law, provides guidance, and so the revisions to the circular are really driven by either changes in law or clarification of policy. And so I've given you a few examples there. Changes in law in terms of hiring preference for veterans employment. There's a number of requirements regarding the procurement of intelligent transportation systems and record keeping. We have had revisions of clarifying policies, as you've seen already when I've talked about use of state schedules, adequate third-party contract revisions. And so that's really where we see changes and revisions of the FDA circular. And we're expecting another overhaul of the circular along with 5010-1D because the Omni circular, which is also known as the super circular, is now, now the regulation applying to all grants awarded after December 25th of 2014. And that circular essentially repeals the Common Grant Rule, although the Common Grant Rule is still in effect for grants that predate that, the Omni Circular. Be happy to talk with you guys about that as well, another huge topic. If we go to the next slide, that'll be the last slide that I'll be talking about. There was a question about FTA clauses and contract terms. I've given you the link for the FTA website where you'll find the FTA required and model contract clauses. Forgive me, this is not my doing. The FTA website just has a number of subpages which are numerical only. I've given it to you there. You punch that in with the underscore, and you will get those clauses. Keep in mind that those clauses are becoming a bit dated. There is actually some outdated language in there. I have been in touch on a number of occasions with the Virginia Attorney General's office when they are doing their work for DRPT, and I imagine that DRPT has a pretty up-to-date list of the model contract clauses. You might want to check in with them if you're looking to prepare your own. Also be aware that the Omni Circular, also known as the Super Circular, has a list in it of required contract provisions in Appendix 2, and we expect that we'll see the supplemental contract provisions that would apply only to FTA contracts probably in the next iteration of 4221F. We at least hope so, or at least on the website. So that's it for me. I'm going to pass the baton to Anthony Romero.
Okay, one of the first subjects we're going to touch on that was asked was the differences between the invitation for bid and the request for proposals. Basically, I'm just going to go through these slides just as they're lined out. Okay, the first slide is an invitation for bid, also known as a sealed bid, leads to an award to the responsible bidder whose bid, conforming to all material terms and conditions of the invitation to bid, is the lowest price. Generally, for this type of procurement, there's no discussion with the bidders, and unless there's a need for clarification of some sort, otherwise discussions are prohibited. Under the request for proposal, an RFP, or competitive proposals, is generally accepted when the procurement does not lead itself to sealed bids and the recipient expects more than one source will be willing and able to submit an offer or proposal. And during this type of process, you are allowed to negotiate with your proposers. Appropriate uses for IFBs. You have precise specifications. A complete, adequate, precise, and realistic specifications or purchase description is available. You have an adequate number of sources, 2 or more, that are responsible bidders, and you'll be leading to a firm fixed price contract. Price is selected based on price and price-related factors. And again, discussions are expected to be unnecessary. So basically, an IFB is based on the lowest bid price to the responsible lowest bidder.
And that term is really important, because it's not just lowest price. It is the responsibility. The responsible bidder portion of it is very, very important.
The appropriate use of RFPs, performance and/or function specifications. The property or services to be acquired are described in a performance or functional specification. You have an uncertain number of sources, and price alone is not the determining factor of award. Discussions are expected, and as related to discussions, this is your negotiation process. Next slide. Sole source procurements. other than full and open competition. A sole source procurement may be justified when supplies and services are available from only one responsible source, and no other supplies or services will satisfy the requirement. Changes beyond the scope of the contract are sole source awards. So you have to be sure that if you're doing a sole source, if they are the only available contractor that can supply your supplier service. Basis for sole source award: unique capability or availability. The offeror demonstrates a unique or innovative concept or capability not available from another source. A single bid or proposal requires a determination of adequate competition. Unusual or compelling urgency. An unusual or urgent need that justifies a limited solicitation to avoid serious injury to the grantee. Or authorized by law. A request for guidance from the FTA is highly recommended for this one.
And if I could just jump in there, I think so. That's just to make it clear that single bid or proposal. That's you've gone out. You expected, you expected competition. You only get one bid in. That requires a review, absolutely, to make sure that you had adequate competition, and that will be for triennials scrutinized. So if you have a single source and what should have been done before wasn't done, or or there were other sources out there, and the advertisement of the solicitation was poor, that's going to come under question. And that's the situation when we're dealing with competition. If you're going to look for an area where you might have a disallowance, that would be it. If there's not full and open competition.
I think it's also important to stress that your procurement files need to be current, up to date. They need to include all of this information. I can't tell you how many times our contractors go out and sole source was done in a certain situation, but the file is incomplete. The documentation supporting the sole source isn't there. It's so important that your files are kept up to date.
And under a single bid, they're going to want to see how far you've reached out. How have you conducted your market research? If you can contacted other agencies that have the same product or item that you're looking for, how well have you done your market research, and how far have you reached out to make a determination that this is an actual sole source?
And just before we move on to the next slide, just look for the last two. For both of them, it's really highly recommended that you seek FTA guidance. You'll see a list in 4221F, if you go there, of authorized by law bases for sole source awards. I won't go into them. But on the unusual or compelling urgency one, I used to work for the FAA, and the only time we ever had a procurement justified on this was after 9/11. So it is very unusual and very compelling in order to do that. So a need that should have been anticipated, that is now coming up within 4 weeks' time. I would say, other than the most unusual circumstances, will probably not justify that as a sole source. So going to Options 101.
Options 101. Ensure that your ICE, which is your independent cost estimate, includes separately any possible options that might be exercised during the course of the contract. Okay, this is, so if you're going to have a invitation for bid and you want options, but you don't know if you're going to actually utilize those options or not, you want to list them as separate line items on your solicitation. However, when you do your cost price analysis before award, you want to ensure that you include those options in your cost price analysis, even if you're unsure if you're going to exercise them or not. Because if you don't do that, then you can't exercise those options, and if you do, they will be considered a sole source award. So list your options separately. Next, ensure bidders are aware that the line items are options which may or may not be exercised during the contract. Include options in the initial cost price analysis, which we just discussed. And before an option is exercised, a written or cost price analysis must be conducted to ensure that the price is fair and reasonable. So you will have to do another cost price analysis down the road at the time that you exercise your option. And make certain that the changes clause is included both in your solicitation and your contract in order to exercise your option. Basis for sole source award.
No, cardinal changes.
Sorry.
Cardinal changes.
Cardinal changes.
So the next slide.
Next slide, yeah. A cardinal change is a major deviation from the original purpose of the work or the intended method of achievement, or a revision of contract work so extensive, significant, or cumulative, I always have a problem with that word, that in effect the contractor is required to perform very different work from that described in the original contract.
Next slide.
Next slide. Cardinal changes. Under rolling stock, a cardinal change could be a major change in quantity, substitution of major end items not contemplated when competition for the original award took place, change in type of vehicle, higher floors, lower floors, passenger capacity, type of engine, or an extension of the contract term length, meaning extend the contract beyond the original term of the contract, which then would be considered a sole source award. For construction, a cardinal change could be performance outside of the original scope of work, or significant changes in time and or material.
And this is Jay Fox, the litigation I referenced earlier, where we had the grantee not only face disallowance, but also litigation from the contractor, or it was the bus manufacturer, was a rolling stock issue, and it was a change in type of vehicle that was made unilaterally by the director of that agency. So that led to a huge number of problems, and also, worse yet, they had desperate need for new buses, which they had to wait for almost another year and a half because of the problems that they had gotten themselves into. I think that's it for our portion.
So, Lisa, that's it from our side.
Okay.
We're going to turn it back over to you.
Thank you. Thank you, FTA, for that informative presentation. Our next panelist is Jamie Motley. Jamie is the Director of Financial Planning and Budget for the Department of Rail and Public Transportation for the Commonwealth of Virginia. Jamie is responsible for the $3.2 billion six-year improvement program that allocates funds for public transportation, rail, and transportation demand management. And he's also responsible for the $580 million budget of DRPT, as well as procurement, and a program that performs reviews of all grantees at least once every 3 years. So welcome, Jamie, and now we'll turn to our Virginia procurement.
Thank you, Lisa. Appreciate the opportunity to talk to everyone today. I don't have a lot of prepared slides like the FTA did, but I did want to pass on some information, and I wanted to talk about our contracts first. You see the link here to our website, and because some of the questions I think related to some contracts and what we were going to be doing. So our list of existing contracts are out on our website, and we've got body on chassis, passenger vehicles, Ford gas, and Chevrolet gas. We've got 7 different contracts when you go out there. They do have all the federal terms and conditions in them, so you can use federal money. We also have a contract for 30, 35, and 40-foot low-floor transit buses. I think there's 1 year left on those contracts. Those also have the federal terms and conditions. And then We've also set up some other contracts, which I'm not sure all the grantees are aware of. But we've got some other contracts that they can also use because we named them as users when we did the RFP for these contracts. So there's the first and probably most important is there's a General Planning Consultant Services for Transit Programs contract. So we've got some contractors under contract, and this one also has the federal terms that you can call up and say, hey, we want to do a purchase order with you. And they're going to report to us on a quarterly basis as far as to what business they've done with you, but you can work directly with them and use that contract, and this has all the federal terms. There's also two other contracts. One's a financial consultant services contract, and one of them is a communications and marketing contract. Now, those two do not have federal terms, so be careful. If you purchase off of either one of those, you're going to have to just use local and state funds. You cannot use federal funds. So just wanted to let everyone know that's available and out there. There were also some questions. Maybe I'll hold off on those until the end and see if any more come in. There's been an issue with people I guess are asking what contracts are we going to do this year, and right now we're getting ready to have a meeting with DGS. DGS has talked about taking over some of our contracts. We're going to have a meeting with them, and it got postponed, and they haven't gotten back with us. So I think there's a pushover on the DGS side to do statewide contracts because we don't really have the ability to do statewide contracts. We can include our grantees, all the transit grantees, and any other grantees that receive money from us if we identify them in the original proposal, but we can't do a statewide contract. So what happens a lot of the time is, happened just a couple of weeks ago, and Old Dominion University will call us up and say, oh, I see you got this contract out here, that's great. I want to buy a vehicle off of it. We're like, sorry, you weren't named in the original proposal, you can't use it. So part of me says DGS doing statewide contracts is a great idea because then everyone can use it. Now the flip side of that is I'm concerned they're going to want to go back to charging a percentage to everyone, and so that's what we're sort of waiting to find out. If they want to take these over and do statewide contracts, you know, part of our opposition is, are you going to charge a fee, and then how responsive are you going to be to requests? So that's sort of going on in the background, which may drive some of the other things I'm telling you this year. Because I think a couple of the questions were paratransit vehicles. Well, all the vans we've got listed on our website are handicap equipped. So they are paratransit vehicles. So there are contracts out there available for that. If you have more detailed questions, maybe you meant something else. When you say paratransit vehicles, that's a pretty general term. Another question was dealing with CNG buses. And if you have a request for us to do a procurement, I would say just send me an email, and then probably what I'm going to ask you is who else needs a CNG bus. In other words, if there's a statewide need, a large enough need, we'll definitely consider whether we have the resources to do it. If it's just one grantee, we're probably going to say, sorry, but we don't have time to do procurement for just a few buses, if you understand what I'm saying. So send me an email, and you'll see my contact information here at the end, I think. And you know, we'll consider whether we can do that or not with the resources we have. Another thing that has come up that's out in a bill right now is cooperative procurements, which I just thought about that when FTA was going through their presentation. There's a bill out there now, I'm not sure if it's actually passed yet, there were some amendments to it, that talks about cooperative procurements. And it basically says, even if you're not involved in the original solicitation, we could do a contract, put an RFP out. This entity cannot be involved or named in the solicitation at all, but then they could come in at a later point and purchase off of our contract. So I'm probably going to need to get with Karen Rocher or someone else at FTA offline and say, do y'all have a problem with that? Because I could see maybe you would, maybe you wouldn't, I don't know. But I would think, you know, now we have to name everyone in the original solicitation as to who's going to be able to buy off of this contract. So that's sort of a change if that bill passes. And again, that all goes back to what's going to happen between us and DGS as far as doing any new contracts. I think that's about all I had, unless, you know, we can go to questions and see if anybody has any further questions. I think just mainly go out, look at our website, and if you have any questions, just give us a call and let us know.
Thank you, Jamie. I know that some of those bills are still on the floor today, so some of those we don't know what the final language is going to be, so we will need to provide an update on some of this new legislation as it becomes law, and perhaps we'll do that at a later webinar or at our annual conference. So if you have not submitted a question yet and would like to have your question answered, please type it into your box on your screen, and we will begin with the questions now that we've already received. Let me move so I can read what they are. Okay. All right. We have a question, and I think this is probably for FTA. In a joint procurement situation, you've referred to contract in the singular. Shouldn't each entity that is party to the joint procurement have its own contract with the winning vendor?
Nope. One contract. There might be a term sheet that's signed by each party, but it's the joint procurement. It's one solicitation. It's one contract that all the entities are party to.
Right. You might have an interagency agreement between the parties involved as to what's being procured and who's
taking the lead.
Taking the lead, exactly.
And that was, by the way, the problem in the Akron Metro cases. It was structured as almost as a botched joint procurement, and that each party was signing their own separate contracts. And each of those contracts, the terms vary slightly, but the bottom line was that they were coming in, negotiating separately. It should be one contract, singular terms for all parties.
Okay, thank you. The second question, I believe, is for Jamie Motley. Has DGS agreed to include federal clauses in the procurement of transit vehicles?
And the answer to that is they have in the past. So if they end up taking some of these contracts over, the current contract we have right now for the 30, 35, and 40-foot low-floor transit buses was done by DGS, and it has the federal term. So we have talked to them, and they realize that if they take these over, there are going to be federal terms that have to be put in the contracts, and they've said they understand that, and they would do that.
Okay, thank you. That is all the questions that have been submitted via the webinar software. So we still have a few minutes available. And Jamie or any of the FTA staff, if there's any, one just came in, just a moment. For FTA, process for very small contracts for services. Is that it? I guess just elaborate a little bit on the process for very small contracts for services.
So I'm just thinking it's contracts that are under $100,000. Is that, which is, by the way, going to be increased to $150,000. So you know, I actually the answer is in many ways no different. You should still be going through the same processes. It changes slightly for micro purchases, which are on I think, what is it, 3,000 or 5,000?
Micro purchases is 3,000, and then except for construction is 2,000.
Right.
So, and anything over that, they should pretty much be following the same process.
Yeah. So I mean, it really is the big difference is the nature of the solicitation itself. Whereas for some of the small purchases, it's it could be somebody calling around and doing their research that way, as opposed to putting out a general solicitation that's advertised. And you'll find if you go through our circular, it pretty much lays out the processes for engaging in small purchases. Keep in mind too that there are some nice exemptions that come along with that. There is a Buy America exemption for small purchases for $100,000 or under, and that will also be increased to $150,000. There's actually a notice for rulemaking on that right now. I hope that answers the question. If not.
Okay. We have another one in. Follow-up question to the joint procurement question previously asked and answered. Wait a minute. I need to finish. It's not showing up in the box. We'll have to skip that. It doesn't elaborate. Let me go to the next one. Is there a living wage requirement in place for all small service contracts? I don't know if that's federal and state, I guess.
Not for FTA.
Okay.
No, not that I'm aware of.
Okay. All right. The follow-up question was not complete. I don't know if you're still typing.
Lisa, this is Jamie. There was one other question I think that was submitted in advance that I'd forgotten about. Somebody had asked if they had to use EVA, and the answer to that question is if you're using one of our contracts or any contract really that has EVA terms in it, then you have to use it, whether it's federal terms involved or not. If there's the EVA clause in there that says you have to use EVA, then you have to use EVA. Now, if you just want to use EVA because you don't have your own system, that's going to be a question for DGS because certain people can use it, certain people can, and they'd have to give you the final answer on that.
Okay. All right. I don't see any others yet. Let me just go ahead and say that we are in the planning stages for our VTA annual spring conference. It will be May 20th and 21st in Williamsburg this year. And if you have any other thoughts about questions for both the FTA and DRPT on procurement or anything related to changes in the law, please pass those questions along to me, Lisa Guthrie. We're in the planning stages now and would like to offer perhaps a roundtable or something to answer more of your questions. I think we do have one more that's come in. Just a moment, please. All right, here's the full question. Follow-up question to the joint procurement question previously asked and answered. Please clarify how each of the purchasers' discrete purchase gets differentiated since you said there is just a single contract. And if there's just a single contract, does that mean that all the purchasers are signatories to the same contract document?
So I'm not, well, this is Jay Fox, so I'm not going to stand in for the grantee's counsel. But if that contract came in, it would be a single contract with single terms. Each of the parties would be signing the contract, but it would be explicitly stated what each of the parties was responsible for under the contract. So that even though it was a single contract with single terms, if there was a breach of that contract by one party by not fulfilling the base contract terms, it would be that party that would be responsible for the breach of contract. So I think that is probably where you're getting to in terms of mitigating your liability. But having said that, I'm not your attorney, and so you know, if you're involved in a joint procurement and you're concerned about individual and joint liability, you know, that should be vetted with counsel, whether that's the city attorney or the county attorney or somebody or a private counsel.
Okay. The other questions that have come in pertain to this webinar and how to get copies of the PowerPoint or how to get the recording. We will be putting a link to this webinar up on our website. I don't know if we'll make it tomorrow if we're getting as much snow as they are calling for, but certainly in the next few days we'll be putting that link up on our website. Our website is vatransit.com. Okay.
And Lisa, can I just jump in for one more second here while we got a little bit of time?
Yeah.
So this is Jay Fox again. So my, you know, my email address was on both the presentation and obviously there on the contact information. I am regional counsel. My preference always is that you reach out to the transportation specialist so that they can field the question. You know, we act cooperatively here. And you know, they're the person, the people that are assigned to you as the grantees. They should be getting that in first, and then I, you know, of course, they're my clients, so we work with them and obviously work with you as well. But my preference is always that you go to them first. I just want to say one other thing about on the Buy America rules. It says in the question that was asked, now and looming as possibilities. So I gave you now, and just to give you a little bit more about now, Buy America non-availability waivers are still very difficult to get. It's a policy that's come down from the current administration. There is a Federal Register of Publication process if indeed there is non-availability. So we usually look for any other way that we can resolve the issue before we take this to headquarters for a non-availability waiver request, which can often be very time-consuming. Looming in the future, I don't have my crystal ball. I can't really tell you, but I would say certainly to the end of this administration and to the next election, you could expect the same policy to stand.
That's one thing also. This is Anthony Romero. I want to jump back to piggybacking. A lot of times when we're reviewing piggybacking files, we ask for cost price analysis during the triennial reviews, and they say, well, the agency who did the original procurement did their cost price analysis, and that's what they were going off of. You are responsible for doing your own cost price analysis for that particular procurement. So I just want to make sure everybody was clear on that. Just because the other agency did all the footwork, you're still required to do your own footwork as well.
Okay. Well, thank you all for helping to navigate through some of these complicated issues, and I expect that people will have some additional questions, and I'm sure if we receive any of those, we'll be happy to forward them on to you. And again, if you have any other ideas about what additional training you or any of your staff might need, please pass it along to us as well. So I want to thank everybody for participating today, and this concludes our webinar, and we hope to see you all at our annual conference in Williamsburg, May 20th and 21st. Registration will be available online soon. All right. Thank you, everyone.